Well, thank you everybody for being here. Good afternoon. GW Law's National Security, Cybersecurity, and Foreign Relations Law Program and the National Security Law Association welcome you to Varieties of National Security Lawyering, a fireside chat between Senior Associate Dean Michael Abramowitz and GW Law's new professor of practice, Jonathan Cedarbaum. I know this conversation will offer a fascinating and informative look into the diverse array of legal practice in the national security field, and I'm excited to kick off our main event. Before we begin, I'd like to introduce Senior Associate Dean Michael Abramowitz. Dean Abramowitz is the Jeffrey and Martha Cohn Senior Associate Dean for Academic Affairs and the Oppenheim Professor of Law. Dean Abramowitz specializes in law and economics, including intellectual property, civil procedure, corporate law, administrative law, and insurance law. His research has been published in everything from Yale Law Journal to Harvard Law Review. Before coming to GW Law, Dean Abramowitz taught at George Mason University School of Law, Northwestern University School of Law, and University of Chicago Law School. And before becoming a professor, Dean Abramowitz also clerked for the Honorable Patrick E. Higginbotham of the U.S. Court of Appeals for the Fifth Circuit. Dean Abramowitz, thank you for being here today, and I turn the floor over to you.
Thank you so much, Kendall, and really excited to be here. And I think this event is kind of the culmination of sort of a confluence of two of Dean Matthews' initiatives for the law school. One of them has been to focus on growing what we now call our National Security, Cybersecurity, and Foreign Relations Law program. It's a little bit of a mouthful, but really highlights the interrelation between these different areas. And so one very important thing we did was promote Lisa Skank, or not necessarily promote, but shift over. She was Senior Associate Dean for Administrative Affairs. And was working on this program on the side and doing an amazing job for a long time. But recognizing the importance of this area, Dean Matthew asked Lisa to work on this program full-time, and she's just done an incredible job of growing the program and growing the curriculum. And I know working with many of you, helping to get jobs and make sure your academic experience is an enriching one. And then second, another initiative of Dean Matthews was to create a type of position called Professor of Practice. And the idea is to have full-time faculty members who have had long experiences not in academia, but in the, I guess I can say real world. Academia is not the real world. And who can bring that practice in-house to our students, to our faculty. And so we have been so fortunate to hire as one of our first two professors of practice, Jonathan Cedarbaum. He joined the faculty last month, and I'm really honored to have this chance to chat with him about his career and about how he's ended up here at GW. So let me tell you a little bit about him, but mostly I'll let him speak for himself. But he is originally from the New York suburbs, and he has two college-age children and a spouse with a very unusual attribute here in DC. Brace yourself, she is not a lawyer. So that is remarkable. She has been a public radio and podcast producer for more than 3 decades. And Professor Cedarbaum has spent more than 25 years in legal practice and perhaps illustrating, but in a good way, the revolving door. Yes. Certainly much time in private practice, in law firms, but also serving in several administrations, the Clinton administration, the Bush 43 administration, Obama, and now most recently the Biden administration. And most recently, you worked as Deputy Counsel to the President and National Security Council legal advisor during the first year, as I understand it, of the Biden administration. But that's not all. So he also worked in Congress as a legislative assistant to a member of the House and in an international organization, a UN organization, the International Criminal Tribunal for the former Yugoslavia. And one thing tying together a lot of these postings in many different parts of our legal universe is that many of them have touched on different areas of national security security law. And so, what I'd love to talk to you about today is about how you how you manage to do all these things and about your thoughts on them. But let me go kind of even further back. So I mentioned you're from the New York suburbs. I feel like I've been following you a little bit through life, except now you're following me. But I also grew up in the New York suburbs. We both grew up in Westchester County. You were in
Yes.
Scarsdale, I believe. I was
The infamous suburb of Westchester County.
the infamous suburb. And I was in Larchmont, not, probably 10 or 15 minutes away from you, but we didn't know each other then. And then you were in law school a couple years ahead of me, so we'll get to that in a moment. But let's actually start with your childhood. And you did grow up in a family of lawyers, as I understand it. And
Yes.
maybe you can tell me a little bit about your very interesting family.
Absolutely. First of all, thank you so much for that gracious introduction. And before I answer the question, let me just say how excited and grateful I am to have joined the GW Law community with all of you. I've met some of you one-on-one, at least across Zoom. For others, this is a first chance for us to have a conversation, albeit in a group. But I hope this will be just the first of many conversations I'll have a chance to have with each of you in various capacities and others in the community. So back to my Westchester childhood and my lawyer-infested family. Yes, I grew up, both my folks were, my parents were lawyers. My mom was a little bit of a trailblazer for women in the law. She was one of 8 women in the Columbia Law School class of 1953, which had 280 students, so 8 women out of 280 students. She graduated second in her class, and when she went out to find a job at a New York law firm, she went around interviewing, and guess what? No New York City law firm would hire her. That's the way things were, unfortunately, back then. One senior partner at one of those firms told her that he might think about hiring her to keep track of all the unimportant details that attended his busy practice because women were good at that. My mom politely explained to him that that was not the kind of work she was interested in. Luckily for her, she got a fantastic job working as a clerk for a federal district judge in the Southern District of New York. And then after that, went to work as an assistant United States attorney in the Southern District. This was in the mid-50s. She was not the only woman in the US Attorney's Office. There was one other, so 2 women out of 55 assistants. And then my mom got married, had children, and while her kids were growing up, she had a varied legal career. She did different things. While my older brother and I were growing up, she mostly was an in-house counsel at the Museum of Modern Art, which was a shift from what she had started out thinking she wanted to be a trial lawyer. But that turned her into a copyright lawyer and other things she learned about, in addition to feeding her great interest in art. And then the minute I graduated from high school, I hadn't realized it. When you're a kid, you don't realize always your parents' life plans. The minute I graduated from high school, I was the younger brother. Boom, she went back to full-time practice at a law firm. She became the village justice in my little hometown, Scarsdale, which led to some interesting events when, say, high school classmates of mine turned up in her courtroom for things like, driving under the influence. But eventually, in 1986, she was appointed a United States District Court judge in the Southern District, which was her dream job from the very beginning of her law school career, and she served on the bench there for 30 years until her death in 2016. There are various things I could mention about my mom and her legal career, but I'll mention one, which is just a suggestion for students here about finding jobs and networking. Luckily for my mom, when 1986, it was the Reagan administration. My mom happened to be a Democrat, but there was an interesting arrangement back then in an era of less intense partisanship between the New York senators. If the New York senators were of different parties, as they were back then, Daniel Patrick Moynihan was a Democrat, Al D'Amato was a Republican, they agreed that whichever senator's party did not control the White House would still get to recommend 1 out of 4 district court judgeships. So she was a Moynihan recommendee. Luckily for her, she had worked in the Eisenhower administration early in her career. But also, as it happened, Senator Moynihan, as some senators still do today, had a merit selection panel. And who was the chair of that panel? It was one of my mom's fellow AUSAs from the 1950s, who had gone on to become a very distinguished lawyer in New York. So just remember, be good to your colleagues and keep in touch with them, because you never know when that may come in handy.
Yeah, that absolutely is true. And indeed, as we move to sort of the next part of your story, that really is true. So I do remember first hearing the name Jonathan Cedarbaum when I got to law school.
Yes.
I think you were 2 years ahead of me, class of 96, am I correct?
Yes.
Yeah, and so I was a first year, and he was a 3L. And he was the editor-in-chief of the Law Review. And so I kind of heard this mythical name, and at some point somebody pointed him out to me. People did that at the time. And so that was obviously a very important position to have at a young age. And many people from that position end up going into sort of careers in academia, but really many different things. And so I'm wondering if you could talk a little bit about about that experience and your law school experience more generally, and how that prepared you, or on the other hand, perhaps had nothing to do with what you later did in life.
Well, let me offer 2 thoughts in response to that. One is just about my law school career. I went to law school late. Originally I wanted to be an academic. I had set out to be a history professor, but I didn't quite make it. Turned out I wasn't so good at archival research. And so I had been running away from my family legal profession, but I finally, the magnetic pull grabbed me back in, and I did go to law school. But when I went to law school, I already had in mind the notion of trying to come down to Washington, D.C. and do a kind of law that was connected to politics and policy. After college, well, as you mentioned, after college, my first real job, I had worked as a legislative assistant for a member of the House of Representatives. This was also in the mid-1980s, and I had a fantastic time learning about how the House worked and seeing how the legislative process worked. And so, although I now have returned to the academic world, I always had in mind trying to become what I had in my head, this notion of Washington, D.C. lawyers who move back and forth between private practice and service in the government, and who do work on legal issues that have public policy components to them. I'm trying to think whether the law journal experience in particular suited me for that in any way. Back in those days, I don't know whether it's still true today, we had a lot of controversies and intense debates over the admissions policies for law journals, whether there should be, people should have to write notes, whether there should be different kinds of canned competitions, and the effect of different admissions policies on the demographic makeup of the law journal staff. And so I hadn't really expected that to be an important part of the job, but it turned out to be a very important part of one. So it was a very vigorous policy debate. Not just site checking and going through the substance of text, but it was a small-scale rehearsal for other kinds of policy debates.
Yeah, good. Actually, that certainly brings back memories of trying out for the journal myself, and there was a new process. I guess it must have been put in place by your successors, if I'm not mistaken. But a new process the year I was trying out, where we had to write 3 edit memos of different pieces, one of which actually was Professor Solov's law school notes. So we had to kind of write him a memo about how he should perform. So everybody was writing the same thing. So you're not to blame for that. But nonetheless, great to hear how your law school experience kind of set you up. So let's kind of zoom all the way, not quite all the way forward, but pretty far forward to your role as National Security Council legal advisor. And so maybe you could start by giving us a little background on how the National Security Council works.
Absolutely. The NSC, as it's known, is designed to promote interagency analysis and debate of every important foreign relations and national security issue to ensure that the president gets the best possible advice from across the government, rather than just relying on, say, one lead department or agency. The NSC was set up shortly after World War II, and it's organized. The NSC itself is actually the president, the vice president, and a number of cabinet secretaries. What we usually think of as the NSC is really the NSC staff, which are the staffers like me who run the process and keep things moving. And the interagency policy deliberation process runs in a giant pyramid. At the base of the pyramid are what are called interagency policy committees. Those are made up of officials at the assistant secretary or deputy assistant secretary level, sometimes very senior career officials, so-called SES, the Senior Executive Service. At any time, there'll be dozens and dozens of those interagency policy committees, because you can imagine the United States, of course, has to consider a huge range of issues that it's confronting on the world stage. Those groups will get together. They'll debate and analyze particular issues. Maybe they'll exchange white papers and analyses. And the goal is to see if they can come to consensus on a recommendation as to what the United States should do about problem X. Many times they are able to reach consensus. Sometimes they can't, and they'll present, instead of their consensus recommendation, they'll present option A and option B, and this, who supports A and who supports B, and here are the reasons why. They'll pass their recommendations up to the next level of the pyramid. The next level of the pyramid is called the Deputies Committee. And as its name suggests, that committee is made up of the deputy secretaries of the departments that are involved in the particular issue that the committee is focusing on. So again, they get together, they debate, they exchange information and analyses, again with the goal of coming up with a consensus recommendation, but if not, divided recommendations and explanations. They pass it up to the next level of the pyramid, which is the Principals Committee. That is the cabinet secretaries themselves who were involved in the particular issue. That Principals Committee is typically chaired by the National Security Advisor himself. Sometimes the president comes in and will chair Principals Committee meetings, depending on what the issue is and how much he wants to get directly involved at that stage. But again, the goal of the Principals Committee is to come up with a consensus recommendation for the president or a pair of options. And from the Principals Committee, a memo will go to the president, a presidential decision memo typically, that will lay out for him the recommendation and the reasons why, or the alternatives and the contending reasons why. So as you can see, it's an enormous, quite extensive process of debate and analysis designed to improve the quality of the recommendations the president gets. So that's the National Security Council in brief. I'll just say one more word about the National Security Council staff, and that is, I think the exact number of National Security Council staffers may be a classified number, but it's a large number of folks. These days, more than 100, and they mostly come from across the government. They come on detail from their home agencies and departments. They're senior officials with great expertise, and they are organized in what are called directorates. If you're familiar at all with how the State Department is organized, it's organized into bureaus, and the directorates at the NSC are sort of similar. About half of them are geographical, so there's a Europe directorate, an Africa directorate, and so on. And half of them are functional. So there'll be an intelligence directorate and a counterterrorism directorate, a defense policy directorate, and so on. And the people in each of those directorates, they're the ones who keep this whole process running. Often they're the ones who are proposing the issues that the committees at the base should be tracking. And they're the ones generating most of the paper trail that the whole process generates. Because at every stage, there has to be background material going in, and out of every meeting, there has to be what's called a summary of conclusions, the SOC, which is a very important NSC document, which is designed to reduce to writing whatever it was that the committee concluded. Now, if you've ever been to meetings where people debated very vigorously, you'll know that when somebody tries to write down who said what and what the conclusions were, there can be a considerable amount of further debate over whether that account is exactly accurate. And so I can tell you socks are often fought over even after the meetings are done. So, sorry, that was a little,
No,
little,
that
little
is
bit.
very helpful and educational explanation. So one further question I have
Yes.
is, how do lawyers fit in? So
Yes.
I imagine lawyers are spread between, there isn't just a legal directorate, I assume, that, or
No,
is there?
there is.
Oh, there is, okay.
Yes.
And are they also involved in the other directorates?
Yes. Okay. So at the NSC, the lawyers are one of those functional directorates. You know, not like in sense like intelligence or counterterrorism, but sometimes referred to as service directorates. That's because we are so important. We are serving across all the different substantive directorates. But yes, the law office at NSC is called the Legal Affairs Directorate. These days, it tends to consist of at least one political appointee, the head of the office, like me, the legal advisor, then a principal deputy legal advisor who may be a political appointee, maybe not. I had a fantastic principal deputy who came on leave from academia. Some of you may have heard of her, Ashley Deeks, who teaches foreign relations law at UVA, and earlier in her career had been a brilliant State Department lawyer. But the current principal deputy is not a political appointee. She's a career State Department lawyer who came on detail, so it varies. And then there'll be about 5 other career lawyers who come on detail, usually one from each of an important national security department or agency. So maybe one from DOD, one from CIA, one from Justice, and so on. And those folks tend to be very experienced senior folks, at least 10 or 15 years, often more time in the government. The Legal Affairs Directorate, or at the NSC, the way people refer to directorates, and this just goes back to the email system, they say pound such and such. So pound legal has a number of different functions, but I'll mention 4. 2 of them are ones where lawyers are, as you said, integrated into the interagency policy deliberation process, and 2, not so much. So the 2 ways in which lawyers at the NSC are an integral part of the interagency deliberation process are as follows. 1, as you said, lawyers have to attend all these policy meetings because one of our important roles as the policymakers are debating is to spot legal issues, to spot legal problems that may arise if they want to pursue a policy, and a lawyer sitting there may say, wait a minute, you know, that official doesn't have the authority to do such and such, or you know, if you want to go that way, you're going to get sued immediately, or what, you know. So we're there. So the line attorneys are sitting in on all of those interagency policy committee meetings. It's a huge amount of their time is tracking all the issues as they're bubbling up, identifying legal issues, and then usually working with the lawyers, in addition to the policymakers, working with the lawyers from the departments represented on the committees to try to resolve those legal issues, take them off the table for the policymakers, so they're only working on, you know, legally available alternatives. And that's true at each level. The deputies committee is where I usually was in attendance. Either I or the principal deputy would be the lawyer at deputies committee meetings. And in addition to dealing with lots of interesting legal issues, it was just a fantastic education about US foreign policy and international relations, being able to learn from these wonderful debates. Same thing though, the goal was to make sure that legal problems had been removed and so on each level up the track. And so that's one important function of the lawyers. Another function related to the interagency process is a legal parallel to the pyramid of policy committees I just described. And that's something called the Interagency Lawyers Group, which is itself a standing committee of general counsels from many of the main national security departments and agencies, like, again, DOD, CIA, Justice, and so on, chaired by the legal advisor to the National Security Council. That interagency lawyers group has now been around through several administrations, and it comes together. We tried to make it a very regular institution in the Biden administration with a standing meeting every week, even though we didn't always have an important issue. But that interagency lawyers group would consider very difficult cross-cutting issues where we really wanted to involve the general counsels of the relevant agencies and get the top level, as it were, views of important agencies to make sure, again, to see if we could come up with a consensus about what the best legal view was, or if there was a division, at least to, refer that division either to our clients or to the counsel to the president, who was my boss. Fortunately, we almost in every case could come to consensus. And those issues were often ones about the use of military force, intelligence activities, but they could vary, but they're usually very difficult and urgent ones where we wanted senior folks involved. Two other things that we in the Legal Affairs Directorate at NSC were regularly involved in were just providing day-to-day substantive advice to the NSC staff. So the different directorates, in addition to participating in the interagency process, did a lot of work implementing policies, putting policies into practice, and legal issues would arise at that stage, and so they would come to us for help. So that was more like a regular attorney-client relationship where your clients come to you and are looking for advice about how to pursue some course of action. And then finally, the NSC Legal Office, like legal offices in other government agencies and departments, was a general counsel's office for a large organization. And so we had to work on all the issues that general counsel's offices work on. We had employment disputes, we had ethics issues, and in the federal government, there are special ethics rules. We had questions about financial disclosures, all sorts of contracts, whenever there were renovations and other administrative things. All of a sudden, I was a contract lawyer again. So we were also a general counsel's office, which brought the array of issues, not always related to national security, that other general counsel's offices would take care of.
And so you mentioned, of course, attorney-client privilege, so I don't
Yes.
know to what extent that will limit your ability
Okay.
to answer questions, but I wonder if you might, at some level of abstraction,
Yes.
talk about some of the range of issues you might have seen
Yes.
during that time.
Yes. I mean, one of the wonderful and difficult things about the job is that the range of issues was absolutely vast. So, I've mentioned things like dealing with military, use of force, intelligence activities, intelligence collection, intelligence dissemination and sharing, covert action activities. Those are the sorts of things you may think of in the headlines. But, at the other end, in one sense, we dealt with all sorts of international economic issues, sanctions programs, export controls, participation of the United States in international financial institutions. We dealt with international environmental issues, pipelines crossing international borders, or bodies of water crossing international borders, disputes over islands or disputes over maritime boundaries. We dealt with lots of cybersecurity issues. I had on my shelf, I'm a binder maker because I'm an old-fashioned, older person. I'm not yet, my kids tease me because I don't read things so well on the computer all the time. I print stuff out, I get my 3-hole punch, I put it in a binder. 2 of the binders on my shelf were cyber defense, cyber offense. I won't say so much about cyber offense, but just to tell you that there were a huge number of issues in both of those general buckets. Of course, the Biden administration has put an enormous emphasis on cybersecurity, making our networks more secure here at home. For the first time in the Biden administration, there was a deputy national security advisor dedicated to cybersecurity, a very smart and vigorous person named Ann Neuberger. And so we did a lot of work on that, including on an important executive order that the president put out on improving cybersecurity. And then we also worked on cybersecurity and international affairs. Of course, as some of you may know, we do have in the military a cyber command. And so there are issues about its activities, but there are also lots of issues about the international law and international norms governing cyber activities across borders. We did a huge amount of work related to the southern border and immigration, which is a terribly important national security issue these days. All sorts of issues about classification and declassification of documents. I haven't even mentioned Guantanamo Bay, which of course is a long-running source of work for lots of government lawyers, alas. And I also haven't even mentioned the two biggest, I'd say, international cataclysms that happened during my year there. One is the withdrawal from Afghanistan, and the other is the Russian invasion of Ukraine. And each of those events threw up an enormous number of legal issues. For example, the withdrawal from Afghanistan, lots of issues about how to deal with the Taliban without recognizing them as the government of Afghanistan, how to handle the enormous outflow of refugees from Afghanistan, many of whom had worked with our government, and many of whom were resettled in the United States. There's a fight, some of you may know, that's going on in court still over who's going to get the $7 billion or so in reserves from the Afghan central bank that were frozen and held here in the United States. So many, many legal issues, and the same thing with the Russian invasion of Ukraine. As you'll remember, that was an event the United States anticipated and really told the world to anticipate in advance. US intelligence, unlike the intelligence services in some other countries, was very ardent in saying this invasion is coming. And the legal work related to that was, of course, much less important than other work, but there was still important legal work done in the run-up to that, and I'm sure there's been very important legal work done as the conflict has unfolded. So, sorry, that was a long list, and the list could go on, I can assure you. So, there's a very wide range of issues.
Did you get any sleep?
Well,
really. So, but seriously,
yes.
though, what is
Yes.
your day like? And
Yes,
it's challenging.
yes.
And of course, many of our students
Yes.
are thinking about their future careers. And
Yes.
we talk about work-life balance, and
Yes.
I've
Yes.
seen these challenges in my own family. But maybe you have some thoughts on that.
The job I was in, it was hard to have work-life balance. I mean, I think you go into a job like the one I was in for a year knowing that you're going to have to work, as I did, 7 days a week. During the week, 15 hours a day, certainly, and every Saturday and every Sunday. I will say I tried to, I came in on weekends and spent more time on weekends, frankly, so that the career folks did not have to come in. There's a constant review process where the paper flow from that pyramid committee structure I mentioned, keeps going over the weekends. And the legal office has to sign off on everything. So it all flows through the legal office. The subject matter specialists, they only have to worry about their own subject, but the lawyers have to look at everything. And so I would try to cover that flow on weekends to let the rest of the office stay home. So it was very demanding in terms of schedule. To give you an example of the schedule, every morning there was a small leadership group meeting by Skype, led by the Principal Deputy National Security Advisor, a very nice guy named John Feiner, who also happened to go to Yale Law School, and a handful of us in leadership positions. That was at 8 a.m. And that was kind of a check-in of, what's coming up today? What are the breaking issues? What's the president doing? What do we need to be aware of just coming up in the next, 8 to 12 hours? Then after that meeting, I would then have to run across West Executive Avenue. I was in the old executive office building. I'd run over to the West Wing because people in my job were dual-hatted. I was the NSC legal advisor, and I mostly spent my time at the NSC, working as part of the NSC staff, but I was also a deputy counsel to the president, and my actual boss was the counsel to the president. I was really just her surrogate over in the National Security Council world. So the NSC morning meeting was at 8. Her morning meeting was at 9. So I'd run across the way, check in with her and my deputy colleagues. Then, go about the day, go to deputies committee meetings, all sort of whatever, your daily work, running around between meetings, reviewing the paper flow, analyzing legal issues, negotiating with people over what the position should be. And then, I hope I'm not giving away a national security secret, but under the current National Security Advisor, Jake Sullivan, he would have an end-of-the-day leadership meeting, which the legal advisor also had to attend, again, a small group in his office. And that meeting had a variable start time. Often it was said on the calendar to start at 7 p.m., but often it did not. And so, the day would go quite late. And then at that meeting, if the morning meeting was about what to expect that day, the evening meeting was what had happened and what new issues had come out of that. And so often the evening meeting would generate new assignments. they would go through their books of what had happened, and you need to look into this, you need to look into that. So after that meeting, you have to run back to your office and start working on the new issues that have come out. So it was a long, long day, but wonderful, wonderful colleagues, and just an endless learning experience. So.
Are there any issues you're able, and again,
Yeah.
I realize you're
Yes.
a little bit limited perhaps, but
Yes.
any issues you want to talk about that were particularly either satisfying or on the other side, frustrating or challenging to work on?
Sure. Let me give two examples of issues that were satisfying. I'm hesitant, but maybe I'll mention one frustrating one. On the satisfying side, the Biden administration took a this is related to Guantanamo and military commissions. There had been debate and uncertainty and shifting in the government's position with regard to the use of evidence derived from torture in military commission proceedings, even though the government of the United States had said repeatedly in international forums that we would not tolerate the use of torture-derived evidence. That had not actually been the position the government had taken in front of military commissions. And in fact, the chief prosecutor for military commissions when I arrived, who happened to be an old friend of mine, a wonderful, wonderful military lawyer named Mark Martins, he had argued that in certain pretrial proceedings, torture-derived evidence could be used. And there was actually a judge for the military commissions who had adopted that position in what I and some others thought was a misreading of the military commission rules, in addition to being a horrible position for the government to be advocating for other reasons. And we worked on changing the position and making it clear that we would not make use of torture-derived evidence. And we filed a brief in the DC Circuit in a case involving a detainee named al-Nashiri, making that position clear. And that was something I was quite proud of being a part of. The second thing I'll mention is not a particular substantive position or the result of a project, but more a process issue. I mentioned the Interagency Lawyers Group before. That group has been active and inactive in various ways across administrations. In the prior administration, it had not been very active. It had really become dormant. And when we came in, one of our goals was to revive that Interagency Lawyers Group. Why is that? It's because process leads to better outcomes. And process is one way to ensure better adherence to the rule of law. Sometimes it's hard to explain that to non-lawyers. I think it's more intuitive for a legal audience like this. But putting in place a good process and ensuring that you get views from different perspectives is one important way that you ensure that the outcome will be a good one and one that is taking account of important rule of law values. So really reviving that Interagency Lawyers Group and making it a vigorous institution is something I'm quite proud of in the Biden administration. The frustrating one I was going to mention is Guantanamo Bay, which unfortunately is still with us so long after its creation. It has thrown up many complicated legal issues over the years. There have been many efforts to close the detention center there and move the remaining detainees to other premises and put them into a different kind of judicial process. Those have all failed over the years for various reasons. And we certainly put a lot of effort into that, and I think, as you can see if you're watching the news, the Biden administration has engaged in a concerted effort to release and transfer, whenever possible, detainees to other countries. When we came in, there were 40 detainees still at Guantanamo. They're now down to about 31, and I think the number is going to continue to dwindle. And it is certainly my hope that if the number gets low enough, the prospects for closing the detention center will finally rise, or that will be a real possibility in a way that it hasn't been before. So that's a very challenging and frustrating aspect of the job, but I think one where at least we were trying to make some progress.
Okay, great. So I have so many more questions, but I want to kind of reduce it,
Yes.
put a whole bunch of things in one.
Sorry.
I want to give people in the audience
Because my
a
answers are,
chance.
yes, my answers are too long-winded.
No, your
I
answers
apologize.
are terrific and incredibly interesting. But I would like to go earlier in your
Yes.
career, and maybe I'll just
Yep.
do the whole rest of the career in
Sure.
one big question. So you worked, for example, at the Office of Legal Counsel in the
Yes.
Justice Department, and we mentioned the Criminal Tribunal for the former Yugoslavia, and also in a law firm. And I'm wondering if at a very 10,000 feet up level, you can give some indication of how the day-to-day work, obviously they're different interests, but the day-to-day work of a lawyer differs across those different jobs and the one we just talked about.
Yep. Okay, let me try to be quick in saying a little bit about some of the distinctive characteristics of those different workplaces, but then also maybe mention one cross-cutting similarity. So the Office of Legal Counsel, as some of you may know, is an office in the Justice Department that specializes in giving legal advice to other parts of the government. So it's really a law nerd's office. It's about 23 lawyers. You don't talk to anybody outside the government. You only really work on problems when they are brought to you by others across the government, so you don't reach out for things. You sit there and you research and you analyze and you write opinions or you give oral advice. And so it's something of a cloistered office, but it's a very intensely collegial office. It's a small office and you're always collaborating with your peers. Contrast that with the International Criminal Tribunal for the former Yugoslavia, a much, much larger institution and an international institution. Working there was an enormously broadening experience for me, and I highly recommend any student here who is interested at all in transnational law, international law, or even if you're not so interested in those things, look for an opportunity to work in an international institution, because one of the things that drives home is how the US legal system is just one part of a much bigger global legal system with so many different forms of legal process, different kinds of values. At the ICTY, as it's known by its acronym, there was, for example, just a basic division between the lawyers who came from common law countries like the US, the UK, Australia, and so on, and the civil law countries in continental Europe. And so I got quite an education in how civil lawyers think, and it was radically different. We had to translate almost for each other. So it was a fascinating way. I mean, I think we know about that from reading books and hearing about it, but actually working with lawyers from different countries and different legal systems is a wonderfully expanding experience. Then a law firm. A law firm, again, is a much bigger institution than OLC. Depending on which firm, it's probably smaller than the ICTY. And it's typically focused on, areas of the law that you'll see less in public institutions, whether international or US governmental ones. When I was at the law firm, I was mostly a litigator. And so that was a different kind of practice of law. And you're, very much focused on finding clients, getting business. That's an important part of your job there that you don't see working in public institutions where your clients come to you. But the one thing I'll say, cutting across these experiences, and including at the NSC as well, is the importance of developing good relationships with your clients and learning to work with your clients in a way that they do not think of lawyers, as many people in the government especially do, as naysayers. Lawyers are the ones who get in the way. Lawyers are the ones who throw on all this extra process. They're going to cause trouble. I want to carry out this policy, but the lawyers are going to, that is not how the relationship should run. And in all these places, lawyers should be looking in the first instance to help their clients find legally permissible ways to achieve their goals. And often, when a client comes to you and wants to achieve some goal, the client may have in mind some blatantly illegal path to getting there. And so it may be your job to tell your client, I'm sorry, you can't do it that way, but you can't just stop there. Your job is to help your client to find a way. And so you look for another path forward. And often, if you're creative, you can find one.
That's incredibly interesting. Thank you so much. And so what I'd like to open it up to questions from the audience. Professor Dickinson.
So first of all, I just want to say what a boon for GW that you are joining our faculty, joining our program in national security, cybersecurity, and foreign relations law. It's just really terrific for our community.
Thank you very much.
So I have two questions. The first one you kind of just answered there at the end, which is
Well, I can say more about it if you pose the question.
yes. So without obviously going into specifics, you know,
Yep.
have you ever found yourself in a situation, perhaps in that when you were describing the different buckets of work, where you're in the role of spotting issues, where you in your role saw something that was pretty problematic from a legal perspective, either blatantly illegal or carrying a lot of legal risks, shall we say, perhaps legally available, but carrying a lot of legal risks. How did you handle that? You know, how challenging was that for you? How did you handle that? And then the second question is really just about the process for crafting executive orders, national security directives, presidential policy guidance, presidential policy memorandums. Sort of, if you could say a little bit about that process.
Absolutely, great questions. Okay, as to the first, let me tell a story and then maybe draw out some of the lessons that I took from it and other experiences of having to break bad news to clients about there maybe not being a legal way forward. And the story I'll give is not from my time at the NSC, but from my time at OLC. In the Obama administration, I was a political appointee in the Office of Legal Counsel, and at the tail end of my time there, for a glorious 6 months, I was the acting head of the office. And as always happens, clients call with the most difficult questions on Fridays. It's a universal rule, so they can go home for the weekend, and the lawyers can sweat out over the weekend what to do with the hard questions. So on a Friday, the deputy counsel to the president calls, and he says, and I want to preserve the confidentiality of attorney-client communications, so I'm going to just describe it at a general level. It was a very important issue that President Obama had promised to do something about during the campaign. There had been it was to change a longstanding policy, to revise it to something more, to a better policy. And there had been efforts in Congress to do this legislatively. Those efforts had failed. And so, as often happens, when there's something that they can't get Congress to address, the president looks for a way to do it unilaterally through an executive order or some other kind of executive action. And I think this pattern of presidents looking to do things unilaterally because Congress has become so dysfunctional is a more and more frequent pattern that we see. It throws up very hard questions for government lawyers, but it's something we see more and more in both parties. We could talk about that separately. But so calls on Friday, can the president, unilaterally address this problem? And here's a statutory provision. I'll mention the title of the US Code. It was Title 10, which, as Professor Dickinson knows, is the code that governs the Department of Defense. We need to know by Monday whether the president can do this, and he's very eager to be able to do something. I said, okay, well, we'll do our best. So I put down the phone. I called up the deputy in the office, who was effectively my principal deputy, who also happened to be a very good friend of mine. I told her what the problem was. I said, forget about whatever else you're going to do over the weekend. You and I are spending the weekend working on this. So we did. I did go home that Friday night, but Saturday and Sunday, I spent 10 hours in the office each day and poured through not only the provision the client had mentioned to us, but other nearby provisions and other provisions not so nearby, because we pretty quickly determined that really wouldn't work, the one they had in mind. So we looked for others. But unfortunately, we couldn't find any. We tried our hardest. We wrote up our analysis as best we could. And come Monday morning, I knew I was going to have to, call or get the call from, in this case, it was the counsel of the president, not the deputy, to get the results of our research. And I said to him, I'm very sorry, Bob. It was Bob Bauer, who was the counsel to the president at the time. You know, we spent all weekend. We looked at the statutory provision you suggested, and we scoured others, but we were not able to find a way for the president to do this. And then I spent about 10 or 15 minutes just running through our analysis in brief. You know, we had sort of talking points we had put together. Here was possibility A, here's why it didn't work. Here's possibility B, here's why it didn't work. Here's possibility C, here's why it didn't work. I can't remember, there were at least A, B, and C. There might have been a D even. And, you know, I was a little worried. Maybe he was going to slam the phone down. Maybe he was going to scream at me. Maybe he was going to get me fired. No, he accepted it and took it in stride. He was disappointed because, of course, he didn't want to have to go tell the president that we hadn't been able to find a way forward. But he understood. Why was he so understanding? Partly, maybe it was just he had anticipated that outcome, and partly it's because he's a very good lawyer himself and a professional. But I'll mention a few things, some of which are shown in that episode, and others come from other experiences of breaking bad news to clients that I take from this. One is the one I mentioned in my earlier answer, and that is developing a good relationship with your clients in which you really convey to them the fact that you are there to help them. You are there to help solve their problems, not create problems. Okay? And you can do that partly by how you frame issues and you approach issues. And certainly I can tell you in this instance, I was an ardent supporter of the policy change that they were looking for. I wanted to find a way. And I told him, you know, I was very sorry that I had not been able to find a way forward. I was very disappointed and frustrated. So partly that's by how you discuss the problem and frame the problem and deal with your client. But there are other ways, I think, in which you can convey that. One is have a track record of finding ways forward for your client. I think part of the reason Bob Bauer accepted that was that, you know, I had had other questions that had come to me from his office where I and others in the office had found ways forward. And he knew I was a guy who, not only in this instance, but in others, was looking to find ways forward. And that therefore, if I was saying no, it was really because I had, you know, looked under every rock. And I was trying to find a way forward. And that's partly from that track record, because I think each time you're able to find a way forward, it's a little bit of, you know, sort of credit in the bank of client confidence that you can draw on when you have to break bad news. But partly also it was in the way I gave the answer, well, what we had done and then what I could tell them we had done. We didn't just look at, you know, the provision they had suggested. We scoured, you know, the statutory realm looking for possibilities, and so we demonstrated we were doing everything we could to find a way forward. One last thing that was particularly important at the National Security Council is being clear to your clients and to yourself that you are strictly in the business of providing legal advice. You're not there to offer policy opinions. Because, you know, obviously law and policy, I'm a good Yale law trained lawyer, law and policy are often intertwined, but it's very important, I think, to make clear to clients that when you're giving advice, it is strictly on the law, so that they know that if you're saying no, or if you're saying something is extremely risky, they know it's not because you have some hesitation about the policy, which is for other people. Making it clear to your clients, even though, you know, I sat in many, many meetings in the NSC where I had very strong views about policy judgments, but I kept my mouth shut because I knew that if I wanted my legal advice to be effective, I wanted my clients to know that when I spoke, they could trust that it was just the lawyer speaking. Okay, and the second question was, EOs and national security directives, national security policy. Yes, one of the things that's another function of the NSC legal office. We set up a whole process memorialized in a memo to create an interagency review system for the creation of both national security memoranda, presidential policy directives that were national security related, and executive orders that were principally about national security issues. And there would be a whole, you know, interagency process that would involve both the policymakers interested in the issues and various levels of legal review. There is a broader process for review of executive orders altogether. So we had to kind of attach our process to that process. But for presidential directives of all kinds that had centrally national security content, the NSC legal office would take the lead in, overseeing this interagency process.
Okay, that's super wonderful. I think I know there would be so many more questions, but I think we're at the time. I think I want to talk. What time are we going till, Lisa? 1:30. Well, we have time for lots more questions.
Okay.
Then that's great. Okay, so I should have checked the time bounds, but I'm very glad because that was just one person's question. I'd love to hear more questions from.
We do have one from
Audience.
the
good.
webcast, if
Okay,
you don't mind.
yeah, go ahead.
So this is a specific topic, and Professor Cedarbaum, please offer us what you can say on this.
Yes.
I'll read it verbatim in fairness to the question asker. The U.S. has long been hostile towards the ICC since it's not a state party to the Rome Statute. I would like to know if the NSC is involved in decision-making when it comes to prosecuting other countries for their war crimes. If yes, is it awkward for the U.S. to do so since the U.S. cannot be held accountable by the ICC?
Okay, well, first of all, I'm looking over at Professor Dickinson, who is an absolute expert on this issue, and I know there are others on the faculty who are also experts on it. Professor Dickinson and others recently, or I don't know who the questioner is, so I'll just mention Professor Dickinson and others recently organized a fantastic workshop precisely on the issue of the obstacles to and opportunities for U.S. cooperation with the ICC over the Russian invasion of Ukraine, where Congress has actually removed some of the restrictions that it had otherwise put in place on U.S. cooperation with the ICC. Does the NSC get involved in those issues? I think it would. Those were not issues that really came up during my relatively brief tenure at the NSC, and in part that's for the reason that the questioner suggests, which is that with respect to U.S. involvement in the ICC generally, there are quite severe statutory restrictions on U.S. cooperation, with some exclusions and loopholes. But as the questioner indicates, for a long time, the U.S. has stood apart to some degree from the ICC. I'm now going to take back part of what I said. One issue related to the ICC that did come up during our tenure was an issue where we changed position from the Trump administration. The Trump administration had actually imposed some sanctions on the chief prosecutor of the ICC and some other members of the ICC legal staff, because as a way of showing United States displeasure with the ICC, though there were other reasons given for those sanctions. Really, it was a policy judgment about U.S. hostility to the ICC, I think. And we did reverse that position, revoked those sanctions as a way of reflecting a more warm approach to the ICC, looking for opportunities for the U.S. to cooperate with the ICC, and that was certainly an effort that the NSC legal office was one of the legal offices centrally involved in it. So that did come up a little bit. I don't know, because I haven't been there in a while, how much the NSC legal office would have been involved in whatever U.S. deliberations are going on now about either U.S. cooperation over Ukraine-Russia investigations, or things like, of course, now the arrest warrant that the ICC issued against President Putin of Russia. I don't know how much the ICC did that in secret, how much they discussed it in advance with some important countries, and if one of those countries was the United States, how that would have worked. Yes, please.
Talk a little bit about the process for classifying and declassifying documents and why that's become such a Was there an FAQ that got circulated or something? I mean, why are people messing this up so frequently?
Well, there is an executive order which periodically gets updated that sets out the process for classifying and declassifying documents. Although there is some debate over this, the president is essentially in control of the classification system. And so that's why it is an executive order, say, rather than a piece of legislation that governs the process for classification and declassification. And that executive order sets out, what kinds of officials can have what's called original classifying authority. That is, officials who can take a document and say, this will have this level of classification. And it sets out a process for declassifying documents, both quote unquote voluntarily, and when sometimes the classification of documents can be challenged within the government, there is a whole kind of internal administrative appellate process by which classifications can be challenged within the government. So, but that all goes really to the process of classifying and declassifying. It doesn't go to what we seem to be seeing in the news of late, which is less about classification and declassification than it is about the proper handling of classified documents. And when you arrive, certainly at the NSC, you get a training on that, about how to make sure that classified materials are handled and secured properly. And we all had, safes in our offices with locks, with combination locks that you had to memorize or otherwise, find ways to remember, where physical classified documents had to be stored. My entire NSC, well, almost the entire NSC, but certainly my entire legal office was a SCIF, a secure compartmentalized information facility, which are these special rooms for the handling of classified information with, double thick walls and other security precautions to prevent eavesdropping. Whenever, we would physically carry a classified document from one place to another, we would never just walk around with it. It would have to be in a folder. And you would always, put documents in double folders if you were, for example, sending them by courier somewhere else in a locked bag. So there were all these trainings and processes that, at least to people like me, regular old, government lawyers, thought everybody knew and everybody was pretty careful about. So it was quite, I think, shocking to people who had to handle classified information day to day in their jobs, that you had so many instances of the mishandling of classified materials. Now, I don't know what happens when you have to pack up a president's papers. It's a huge amount of material, or a vice president's papers. So I don't mean to, criticize and point fingers. People make mistakes. I'm sure it's not because they weren't trained. It's because, well, at least in many of these cases, human error, whether in one of these cases it was something else, we'll yet to see. I think, one of the bigger issues that these episodes remind us about is the problem of overclassification. I think, that is another problem that for decades has been debated inside the government and outside the government. And I think people across the political spectrum and of different policy views really all agree that there is too much classification. And with the shift to digital information, which has only exploded the amount of information that is produced, and therefore the amount of information that is classified, the problem of overclassification has probably only gotten worse. So, but I have yet to see a really effective proposal about how to change that culture of overclassification. There's actually a professor of history at Columbia University, who's a professor of international history, who's just written a book about, I think it's called The Misinformation Engine. And part of it, I think, I haven't read it yet, I've just read reviews of it, is about how this culture of overclassification has sort of grown up over the decades, especially since the Cold War, and how it has been so impervious to reform. But it's something that has been crying out for reform for decades. Senator Moynihan, who I mentioned before, was the head of a commission back in the 1990s about what to do about too much secrecy. And he wrote a book that was based on the final report of that commission. And Senator Moynihan, as some of you may know, was thought of as a foreign policy hawk. He was not generally a critic from the left of US foreign policy. He was somebody who supported I'll say a vigorous foreign policy. He was quite supportive of the military and the intelligence agencies. But his book, his commission report in his book was quite scathing about overclassification and what it does to the ability of the public to understand what the government is doing. And that's certainly what this book by the Columbia professor I mentioned is all about. And I think a number of commentators have correctly pointed out that that's the bigger issue lurking behind these episodes of mishandling of classified documents.
Thank you.
Here you go.
Okay. All right, go ahead.
Hi. My question's about the withdrawal from Afghanistan.
Yes.
And one of the big issues with that was, how do we deal with sources in Afghanistan who we were kind of leaving behind or trying to get them to safety as the Taliban was closing in? Did you encounter that issue in your work, and kind of what were some of the challenges, if you did, associated with that problem?
Yes, that was an enormous problem that was the focus of the work of many people at the NSC and across the government. There was, at the time I was there, the deputy Homeland Security Advisor was tasked with doing nothing but trying to organize and oversee an efficient process for ensuring that as many of those people found a safe way out as we possibly could help them do. Most of the obstacles to that were not legal. Some of them were, because sometimes it had to do with problems in the processing of certain kinds of visas that would enable them to get out of the country, and problems in processing those visas rapidly enough, and for perhaps relaxing some of the documentation requirements to enable them to get through the process. And then also, once they had come out, they usually were not coming directly to the United States. They were going to halfway points, different places around the world, how to get them from those places into the United States, because there were additional screening that had to be done for people actually to come into the United States. And as I said, there was a whole working group, mostly non-lawyers, but also, for example, with a lawyer from my office as a dedicated member working on the legal issues attached to that process. And for months, that working group worked, 7 days a week, 12 hours a day, because it was such an urgent and overwhelming priority that, alas, I think, even having been part of the effort to do as well as we could, I think, the evidence shows that we did not get out everybody we should have gotten out. And of course, there's still people, folks outside the government, veterans groups and others who tried to work to help still today other Afghanis get out who were not able to get out before the Taliban takeover. The problem was aggravated by the fact that, of course, the collapse of the Afghan government and the Afghan military occurred much faster than most people thought, certainly than the Taliban thought, as they said at the time, and then certainly that the Afghan government thought. So the amount, I think US policymakers, with regard to that problem, as with regard to other problems in Afghanistan, wound up having a much shorter period of time to try to address the problem than they had thought they would have at the outset. You know, if they thought they might have 6 months or a year to bring those people out, it turned out, well, they had 6 weeks, that kind of thing. And you know, we can debate, you know, whose failure that was. But with respect to the problem you're talking about, that aggravated the problem. But it was certainly something that the law office, along with this interagency group of non-lawyers, worked very, very urgently on.
Thank you.
Sure.
It seems to be true, regardless of where you work or what you do as part of your career, you, by being beholden to the system that surrounds you, it could be a law firm, it could be, you know, government work, you think, wow, this is a really great system, it needs improvement in some capacity. So I'm curious, with your experience across all these different areas, what an area of improvement you know, have pondered or thought about when it comes to the national security legal apparatus that surrounded you during your tenure?
Very good question. Okay, let me, I'm gonna pause and think for a moment about that. I think, well, I think that one possible improvement, which I think of more from my time at the Office of Legal Counsel perhaps than at the NSC, but it's in a way related to the issue of overclassification, is I think our system would be better if more of the government's legal views and legal justifications for its policies could be made public. You know, there's a huge amount of legal work goes on just inside the executive branch, and especially with respect to national security issues. A lot of that legal analysis never gets into a court, never is subjected to adversarial scrutiny. And I think that's unfortunate. The more, you know, adversarial scrutiny that you can simulate within the executive branch by things like the Interagency Lawyers Group, or to take another job I've had at the Foreign Intelligence Surveillance Court, where they created a system of court-appointed amici who are there to challenge the government. The more you can build in adversarial process, I think the better the result is. But still, much of that government executive branch legal work never sees the light of day. And I think it's very important for the public to see more of that. There's been, I think, more of a fight on that issue with respect to the Office of Legal Counsel than probably with respect to the NSC legal office. There have been efforts over the years, even in Congress, to mandate that OLC make more of its opinions public, which I think would be wonderful. There have been some great FOIA suits brought by the Knight Institute at Columbia, which is a First Amendment institute, that have succeeded recently in unearthing at least older OLC opinions. And I think it's wonderful that, you know, outside lawyers should be able to see the legal basis for what the government is doing and you know, scrutinize that and criticize it, because the next time around the issue comes up, the government lawyers who work on it will have the benefit of those critical views. So I guess that's one area where I think there could be substantial improvement.
Can I just ask a follow-up on
Yes,
that?
please.
Does the switching of teams provide a proxy for that? Occupant 1 replaced by occupant 2, and so forth. They then, each occupant gets to read the prior occupant's memos and discuss with friends and whatever way is appropriate. I mean, even if it's only in a skiff, they can still find friends in skiffs in other parts of the government.
Yes.
You know, there is indirect reflected sunlight.
Well, I think that that's an excellent point, and I think you're right. There is critical scrutiny and reconsideration of legal positions across administrations, particularly when there's a switch in party, but not necessarily only when there's a switch in party. So I think that's an excellent point. That's another source of getting a certain kind of sunlight and a certain kind of alternative critical view injected into the process, but it's still sunlight filtered through the blinds of a skiff. And so it's still other government lawyers, other folks inside the executive branch. It's still not quite, the public, which is who we're all serving and whose interests we're seeking to advance. And so it's still one step away, I think, from that greater exposure of government legal analysis that would be great.
I'd love to follow up as well,
Yes, sure.
particularly on the Office of Legal Counsel. So I think there are those who are cynical and think that perhaps it's not merely a problem of the great legal analysis not being revealed, but that a lot of that legal analysis is heavily driven toward trying to get the administration what it wants. And indeed, the joke is that from one party to another, nothing. There are many different policy views, but everybody believes in a strong executive,
Right.
no matter who the president is.
Yes.
And indeed, I think many of the personnel on the OLC kind of remain the same from administration to administration. Of course, the political appointees change, and yet you see, to the extent that opinions are released, they tend to be very, very much in the direction of having a very expansive executive. And so are we wrong to be cynical? Should we think, well, yes, maybe they believe in a strong executive, but they also believe to some extent in the rule of law? Or is the cynicism, if anything, too restrained?
I am not a cynic on this point. I do think it's true that, yes, places like the Office of Legal Counsel and other executive branch agencies, they're, as I said before, they're trying to get to yes for their clients, and they have an institutional commitment and interest to the authority of the executive branch and the president. And so there is that consistency, and there's actually, I'm sure there's more than one scholar, but there's a scholar named Rebecca Ingber, who I think is at Cardozo, who actually may be at the State Department right now as the counselor on international law in the State Department Legal Advisor's Office. She's written at least one, if not more, articles on the point basically you're describing, that there's a sort of one-way ratchet in terms of ever greater executive authority across administrations. And there is, I think that is a real phenomenon. But I think there are still differences across administrations about the kinds of constraints on executive authority that should be recognized in certain circumstances. You do see significant change across administrations, as you did from Bush 43 to Obama with respect to, for example, some of the war on terror opinions and the so-called torture memos, things like that. You've seen it in changes between the Trump administration and the Biden administration on a range of issues. To pick one where you had a long OLC opinion from the Trump administration, and then early in the Biden administration, you had a long OLC opinion directly reversing the earlier opinion. This was the issue about whether the Treasury Department had to turn over to the House Ways and Means Committee tax returns and tax return information of President Trump, because there was a special statute mandating that. So you do have changes, though I do agree that they're often operating in this pro-executive frame. But I think, and it's hard within the government, within the executive branch, which is only one part of the government, to push against that trend. And so, how can you do it? You need to get the issues out into the other branches of government. Either you need to get them into the courts, or you need to get Congress to push back. Unfortunately, because Congress has become so polarized, and again, I'm not a legal academic, but I think there's been legal academic writing on this, we don't have a separation of powers anymore, we have a separation of parties. Darrell Levinson at Harvard, I think, was one of the ones who wrote one of those early articles about this. And so because of the bitter division between the parties in Congress, Congress does not defend its institutional interests in the way it did. If Congress really could unite, at least to defend its institutional interests, you would have a lot more, I think, institutional pushback, or as someone once said, some check and balance on this pro-executive legal trend. I mean, Congress has been outmatched on the legal front, in part for this reason. And then back to the public. That's another reason why, if we're going to have pushback against that pro-executive trend, we need to get more smart lawyers from outside the government to see what the executive branch lawyers are doing and to really, offer the alternative view.
Perfect. I think we have time for one final question. Is there one online, or?
I think I might
Okay,
I might
great.
steal it.
Please.
Based on your breadth of experience in national security law, is there one area that you see that's kind of piqued your interest, or that you foresee becoming the next big thing? Sometimes I've heard, keep your eye on the next big national security thing, and everybody knows cyber, but do you have a prediction or an impression?
Well, cyber is a great area that will be expanding and changing. Sort of related to cyber is artificial intelligence, which of course is very, very important, not only in the national security realm, but in other realms. But I say that in part because I think it's true, and in part because, am I allowed to mention the new faculty member we are going to be welcoming, or no? Okay, I
Why
won't
don't we
mention
hold
her
off on
name,
that?
but I believe you will be hearing soon about a wonderful new faculty member coming to GW Law School who is an absolute expert on the emerging law concerning artificial intelligence. And so I think you'll have somebody close at hand. I mean, you can also work with Cedarbaum, but I know much less than she does. And so he or she, whoever it may be, that's, I think, one area that will have enormous impact. And there's a wonderful new book. Sorry, I love recommending books, but there's a fellow at the Center, what's CNAS, Center for a New American Security, named Paul Scharr. He's a former Army Ranger who is now a brilliant national security policy thinker, who's just written a book called, I think, The Four Battlefields. And it's about the impact of artificial intelligence on war. So that'll be a great place to start.
Okay. Well, thank you very much, Professor Cedarbaum, for joining us in general and at this event.
Thank you so much, and thank you to all of you who came.